And with that, I'm going to get ready to turn it over. But before I do that, we do have our first poll question to kind of see who we have in the audience. So I'm going to launch our poll question here. Have you ever handled a divorce in which there was domestic violence? And while our answers are coming in, I'm going to go ahead and introduce our presenters today. We have Lynn Pence and Riley Cauley, both of the Center for Arkansas Legal Services, who will be speaking today. And I'm going to give just a few more minutes to, or not minutes, seconds, I guess, to let everybody get their answers in. Looks like we've got most everybody, and it's half and half. So I will turn it over to Lynn and Riley.
Hello, everyone. My name's Lynn Pence. I'm an attorney with the Center for Arkansas Legal Services. This will be my last presentation of any sort because I'm retiring in a couple of weeks, but I'm delighted to be with you guys this afternoon. I've been at Legal Aid for 35 years and have seen a number of changes in the law, significant changes in domestic relations. So today we're going to talk, I'm going to give you information about the Center for Arkansas Legal Services, how to contact us, what we do, and then I'm going to give some information. In the last years of my career here, I have been doing almost exclusively domestic relations. And I am so sorry. In fact, I probably need to somehow not get telephone calls, but I don't really know how to do that either. That's why I'm retiring. Anyway, so I have at Legal Services, the domestic relations priorities that we have require an element of domestic violence to either a child or to the prospective applicant. And these cases are different in that these survivors have, they've been through trauma. And so over the years, I've developed kind of an approach to try to help me be a better advocate and provide help to provide better outcomes for folks. So Riley, if you'll go ahead, I guess I'll just say next every time. So this is our vision and mission statement at the Center for Arkansas Legal Services. We partner closely with the Access to Justice Commission and have similar missions and views of legal services. We are a private nonprofit corporation. We provide free legal services in civil cases to low-income folks, which is about 130% of the federal poverty guidelines. We get most of our funding from the Legal Services Corporation, which is a federal agency. And legal services is available all over the United States. Next. So as you all know, as practicing attorneys, not everyone can hire an attorney. They don't have the money, and outcomes in court and in litigation are often not great if one cannot hire an attorney. So we try to fill that gap, and more recently, since we've had limited scope representation as a tool, we more and more we've always given advice, and we have lots of resources on our website, but we're also doing more and more drafting of pleadings, responses, and those sorts of things, so the folks will have a better outcome in court. You can see there only 14% made their way to any agency. Go ahead, Riley. And I would say, I mean, we get, Legal Aid of Arkansas is our sister program, and we get thousands of calls every year and more than half, substantially more than half, are turned away because we do not have the resources to help everyone. And I was going to say, I see here there's Christy's going to be watching the chat for me, but I do want to, after I do this introductory material, maybe she can look at the chat and we can answer questions, because I want this to be a give and take sort of thing, and answer questions as we go. Next. Again, what I mentioned, we try to always give counsel and advice, but we provide full representation in court and in administrative hearings. We do a lot of legal clinics. Sealing records is particularly important to our population of applicants. We do lots of community education, and I'll give the first pitch right now. We can provide so much more representation with the help of the legal community. Our volunteer organization is Volunteers of the Center for Arkansas Legal Services, VOCALS. And so I would urge you to sign up and become one of our pro bono attorneys. If you are a young attorney, we have a monster, excellent pleadings bank. We mentor, we'll co-chair, do whatever we need to help you help one of our clients. And we value our pro bono attorneys so much. So please volunteer for us. Next. So here are our case priorities: economic stability, protecting children and families, ensuring affordable, habitable housing, which of course in Arkansas we do not have, because we do not have a warranty of habitability. And we're the only state in the United States that has a criminal eviction statute. And we have particular priorities for marginalized populations, folks whose English is not their first language, the LGBTQ community, persons of color. Those are, and we have a special opioid grant, and try to help older folks as well. So in the area of improving economic stability and conditions, we provide representation in public benefits like SSI, SNAP, health, Medicare, Medicaid, consumer protection, including bankruptcies. We do lots of unemployment. That has been an area in the last 18 months in which lots of folks have needed help, because frankly, the state has not been great in getting folks their unemployment on a timely basis. Special eds, and then we do special ed, and then we do lots of wills and estates, powers of attorney. Next. Then in the area of mostly domestic relations, as I've mentioned already, domestic violence is a priority. We do guardianships for adults and minors. Any other of the domestic relations areas like paternity. Next. This has been another huge area in the last 18 months. And as many of you know, the federal eviction, or the CDC eviction moratorium, is about to expire. But given the fact that Arkansas, in my view, has the worst landlord-tenant laws in the United States, which basically means tenants have no rights at all, this has always been an area that we have tried to devote a lot of time and effort to. In that, we also do, and housing retention and mortgage, whatever they're called, where you redo your mortgage, anyway, those that we have bankruptcy attorneys that do that, which helps to prevent foreclosure. And then if we do fair housing as well. Next. So these are our marginalized populations that I went over briefly before. And here's how you get in touch with us. There's our website. As I mentioned, these are public. We have a legal library, we have fact sheets, and then we have self-help forms in the areas of name change, uncontested guardianship, divorce with no children. And we are always expanding the resources that are available online. We are looking at adding, for example, pro se divorce forms that include children, more complicated sorts of things. I mentioned earlier that Legal Aid of Arkansas is our sister program. They are in the orange on this slide. So basically, they provide services in counties north of Interstate 40 and down into the Delta, and we provide services in the rest of the state. Yeah. And our offices are located in Little Rock, Pine Bluff, Fort Smith, El Dorado, Hot Springs, and Russellville. But if you call the wrong program, we'll tell you how to get in touch with who you need. Next. So we have online applications, and but we do initial intake over the telephone between 9 and 11 and 1 and 4. And again, we are expanding to try to be available. We are looking toward a weekend time as well as an evening time. But for the time being, you see our 800 number there, as well as our local Little Rock number. Next. So I was going to pause here and ask you, Christy, are there any questions that I can address before we go into kind of the particular hurdles and barriers and challenges for serving survivors of domestic violence?
We don't have anything in the Q&A yet.
Okay. Am I talking loud enough?
I think so, yes.
Okay. All right. So Riley, in half an hour or so, is going to talk about kind of the nuts and bolts of divorces. But to start things off, I think it's really important, especially for survivors of domestic violence, that we approach every case with certain things in mind. And that's what I'm going to talk about in the next 20 minutes or so. So when one interviews, I think it's the most important thing is to listen. And it's also important to do your homework. And that is to look at police reports, any other information that you have available so that you'll have a framework and you won't have to, you would do as little re-victimizing and re-traumatizing as possible. Because this person is a survivor, someone who is hopefully you're going to help have a better life outcome. And it's really important to keep those things in mind when you're doing the initial contact. With the folks that we serve at Legal Services, there is often 3 major factors in that person's life. There's the abuse by a life partner or abuse of a child. Often those lead to mental health issues like PTSD and anxiety and depression. And then often because of the isolation that survivors often suffer, there's self-medication with illegal substances. So keep those things in mind. One of the dynamics of domestic violence is isolation, both physical and emotional. And so folks often don't have resources to leave the situation, to get medical care or any of the other basic needs that they have because they are so isolated. So often the first thing we think about is, why didn't you just leave 10 years ago before your children started exhibiting anger and aggression? But it's not as simple as that. The folks that I work with, often their education level is not high, though not always. And they are survivors. They know how to keep from being seriously injured or killed when leaving a situation with domestic violence. That's the most dangerous time. That's when folks are most often hurt. And so we do safety planning with folks, like your birth certificate, your social security card, your keys, some cash, anytime you get hold of it, emergency numbers, and then those important documents for your children as well. So I think it's super important to know what's available in the community where you practice law, like domestic violence shelters, food, those kinds of services, so you can share those with your client. Next. Again, things that you probably are already doing: a complete history, so that you'll have a relationship with your client in which there is trust. I have often had clients either tell me partial truths or outright lies, and that happens more often when you do not have a trust relationship with your client. Survivors of domestic violence will take way more of your time than a regular contract case or any other type of case that does not have these special factors. And in order to be a good lawyer for a survivor, understand that you are not a social worker or the person's therapist. One of the first conversations I have with a client is, who do you have to talk to? If you have a therapist, involve your children in therapy. But I am not a therapist. I'm a lawyer, and I can help you with the legal part of your life. But the other things that you need to talk about, you need a good therapist or other support persons. I've had clients who grew up in homes where domestic violence was the norm and didn't think that they were victims or survivors of domestic violence because they didn't ever have any broken bones, although they'd been choked to unconsciousness in front of their children. So our backgrounds are not all the same. So it's important to figure out where you are in relation to your client. Next. So of course you would always try to figure out what problems this person has, but also what this person wants. Again, this person knows how to survive. If it's going to make the batterer have an anger episode to ask for spousal support, for example, that is the decision of your client. It is not yours to make, and it could be a survival technique of this person and this family. Always use simple, non-legal terms, and always ask, do you understand? Are you with me? Again, explain your role and your responsibilities, and then what your client's role is. It's her case. She'll be making the decisions, but it's your responsibility to say, you've only been married a year. In Arkansas, property is not divided by fault. And even though you've survived horrible physical battering, that doesn't mean that you're going to get a larger than normal share of the marital property. And then it's also important to make it clear what you expect of your client. Basic things: stay in touch with me. Don't talk to the opposing party, especially if there's an order of protection, because that's a violation, and the judge will believe that you are not afraid of your batterer if you continue to have contact. Those sorts of things. Next. Explain the judicial process and a realistic assessment of what may happen legally. given the judge you're appearing before. Some judges are more educated about domestic violence and know that on an average, a survivor separates 7 times before there is a final separation. Again, don't judge. And as I've already said, let the survivor be the decision maker. It is her case. Never any dumb questions. Your client needs to trust you to do what she tells you to do. Again, that you're giving legal advice. And if you feel that her expectations are not something that is going to be achieved at trial, I think it's really important that you let her know that that's not going to happen. And there have been times where I've said, I think, I'm not going to be able to get what you think you deserve. And so maybe you would be happier with another attorney. And also to get a second opinion, which is probably hard to do whenever there is an attorney of record. Folks who are surviving domestic violence are grieving. It is a grief process. And so I often, if I get a phone call that is non-emergency from a survivor, but more of a cry for help with no danger, I often wait. I don't return the call till later in the day in the hopes that my client will be at a better place and we can have a better, more productive conversation. You are going to, but do return phone calls the same day if at all possible. We've not been able to meet in person, and now we have another spike in COVID with the Delta variant. So as long as you can be safe, I think it's really important that your client see you and that you have interaction with your client. And Zoom is a great way to do that, or the other media things where you can see each other's faces. And I've already talked about a relationship of trust. Next. So preparing for trial. There are folks out there with whom your client has a relationship that can really help you from both a legal standpoint and helping your survivor client in court. So shelter advocates, victim witness coordinators, healthcare providers, they can not only help you develop evidence, but they can also be a support system for your client. If there is an advocate or someone who maybe is not going to be testifying, that person should be in the courtroom, not at counsel table probably, that wouldn't happen, but at least within view of your client to provide emotional support. Be wary of mediation in cases that involve domestic violence. And it's really important that I haven't always in the past, if it's just a property issue, I've not necessarily gone to mediation, but I always do if there's domestic violence. Because if you do not, that atmosphere that the parties had and the power that the batterer has over the survivor often redevelops in that mediation. And you'll go in and you've got an agreement, and then all of a sudden she says, well, no, he can have joint custody. So it's really important to prepare for mediation as you would for a trial, but also to be there so that your client does not become intimidated. I always draft trial questions. I go over them. I give them a copy. I do that with the witnesses too. And on a case-by-case basis, one needs to decide how much detail is going to be necessary given whatever exhibits one has. If you've got exhibits of bruising and physical injuries, then maybe you don't need to re-victimize by going through specific details. On the other hand, the grief process also includes a phase of empowerment. And if that is something that is important to your client, and she will be able to do that at trial, I think that's important for recovery. Next. I've already talked about somebody in your client support system being there. They don't need to be testifying in case the rule is invoked, and I always invoke the rule. I also try to, if I can, position myself between my client and the batterer so that he cannot have direct eye contact through the entire proceeding. I always alert the bailiff if I think the batterer is dangerous. If there are criminal charges pending, I want the bailiff to know that. For me, when you get into court, you're focused on testimony and listening to what both the judge and the witness are saying. So I always give my client a legal pad so that she can write rather than talk to me. It's also important to be safe after the proceeding. Have the bailiff or someone from the sheriff's office go with you out to your cars. And my experience has been that court personnel are very grateful to be told this person is dangerous. This person has felony battery charges pending against him. Help make us safe. They're grateful for that. Next. Then some best practices thing. We have a number of folks in Arkansas who are experts and can be expert witnesses about dynamics. We have a judges a lot of judges who took the bench January 1. And so if education about domestic violence is an issue, these folks will testify for you free of charge. In the area of orders of protection, in the past, and maybe our new judges will be different, but often orders of protection are dismissed because there is a restraining order in an accompanying divorce or paternity or whatever kind of case. They are two entirely separate causes of action. So I never, or very rarely, agree to dismiss an order of protection. Now, if the chances of getting a permanent order of protection are slim, in other words, it's a he said, she said, then our practice in our office, Riley and I, often draft a particular type of restraining order to have entered in the accompanying case that has the provisions of the order of protection, with the exception of the warrantless arrest, to make a stronger restraining order in the divorce case. Again, mutual orders of protection, that is not a best practice. A person who's asking for an order of protection has to file a petition and an affidavit with allegations of abuse in each petition. So the judge, if he or she says, well, I'm just going to do a mutual restraining order, it's incumbent upon you to say, Your Honor, the other party does not have a petition pending. The other party has not set out allegations of abuse by my client against him or her. And that's important, especially if you're setting things up for an appeal. Next. And we're always looking for issues that impact a number of people. So what I was just talking about, the sua sponte dismissal of an order of protection by a judge just because there's a restraining order in an accompanying case, object to it. I have attempted to appeal the dismissal of an order of protection when my client had not hired me, and so her um, um, saying I don't want my order of protection dismissed, I lost because the issue was not properly preserved for appeal. But again, that's an important issue for folks that we're trying to help. Then in Arkansas, and we've just had some legislation on joint custody. I think that becomes effective today about joint custody. But joint custody is not the preference, and there's not, and if there is domestic violence in the case, judges have had poor rulings where the judge had signed an order of protection protecting my client and then awarded joint custody. Well, how is that going to work for this family? So those are things to look for. And if you're not interested or interested in partnering with us to appeal some of these things, call one of us up and we'll figure out how to get some of these issues up on appeal. And then again, be aware that, and this was more of a problem in the past, but it still is an issue. It is that sometimes the Department of Human Services believes that a survivor has failed to protect her children if they're exposed to or hurt by violence in the family. So that's an issue to look for as well. Next. So again, keep your relationship with clients who are survivors in that place where you aren't taking on a role that you are not trained for, and you have to take care of yourself or you can't help anybody else. So Yvonne Martinez is our pro bono coordinator. So please call and sign up to be a vocals attorney. All right, Christy, any questions?
We still don't have any questions in the chat. Don't be shy if you have a question out there.
And if it's not something, so our email addresses, mine is lpence@arkansaslegalservices.org. I'll put it in the chat after Riley starts his presentation. I'll put both of our emails in there, as well as our direct numbers. Thank y'all.
All right, my name is Riley Cauley. I'm a staff attorney with Legal Services. Like Lynn, I do exclusively family law cases, and so pretty much every one of my clients is a victim of domestic violence, and a lot of those issues that Lynn touched on are prevalent in my cases as well. I'm going to talk with y'all about kind of the basics of the divorce process, and hopefully kind of touch on a few things that Lynn mentioned in terms of some new statutory law that has recently gone into effect, to hopefully just make everyone aware. And obviously I can't go too in depth into it, but if you're just aware that it's going into effect, then you can go and look it up yourself if you practice in this area. So a divorce case typically starts with the filing of a complaint with the circuit court in the county in which the plaintiff is currently residing. Filing fees are typically $165 if you're filing in person, or $185 if you're filing electronically. As I'm sure you're all aware, lawyers are required to e-file whenever it's possible. So, I primarily practice in Pulaski, Faulkner, White, and Lonoke counties, and all of those have e-filing except for White County. So, we're doing a lot of the e-filing with the $185 fee. Also remember to fill out the applicable AOC cover sheets and confidential information sheets if those apply to the case that you are filing. If you're going to need a summons, $2.50 fee for the clerk to issue a summons. And again, depending on the county you're filing in, that can either be issued by the clerk's office, where they'll prepare everything for you based on the contact info of the parties if you're filing online, or in my case, for cases I file in White County, I'll have to prepare the summons myself based on the form. I think there's a form on the arcourts.gov on the judiciary website that can help you. You can essentially just pull that right off and input your case information into that. If you're requesting a mutual restraining order, you can submit it at that same time when you're filing your complaint and getting your summons issued for service. Some counties, the judge's signature will be stamped on by the clerk's office, and in some counties, it'll be sent up to the judge for approval. And then if there's children involved, I know in Pulaski County, anytime you file a divorce case and custody is going to be an issue, the court will order both parents to attend a transparenting seminar. So pay close attention to those, I'll say, kind of initial orders that are filed by the judges in whatever county you practice in, because a lot of times, it's important to make sure that you have that on your radar, that, hey, my client needs to take a parenting class, or, hey, the judge entered this standing restraining order that may impact, travel outside of the state, or getting rid of property, or custody, or anything like that. So after you file, you have to serve the other party, or they can waive service. Be sure, like I just mentioned, those orders that are initially filed by the court, be sure that you serve those as well as your complaint and summons. So if it's in order to attend transparenting seminar, if it's a standing restraining order that's going to impact custody or restrain parties from getting rid of property or leaving the state with the child, make sure that you serve that on the other party as well. Service has to happen within 120 days of the date you file your complaint. I believe all of the all of the states of emergency and Supreme Court orders and all of that stuff that was impacting and putting a hold on that 120-day period have been lifted. So to my understanding, that's back in effect. So I know there was a point in time where that 120 days was kind of, pushed to the side while we were dealing, in the initial stage of COVID. But like I said, I believe that's going to be back in effect. So that's another thing to kind of, just keep in the back of your mind, that there is a time limit on filing. For uncontested cases, we typically will, if the other party in the case is the other spouse is willing to work with myself and my client, it's often fairly easy to get them to sign a waiver of service and entry of appearance that you can file with the clerk, just so that you don't have to worry, about trying to track them down if you think they're trying to avoid you, or if they've moved since your client and they, this other spouse have split up. That can make it a little bit easier in terms of trying to ensure that you have good service in your divorce case. And then, as I'm sure everyone's aware, after service of the complaint and summons, the other party has 30 days to file a timely response to that case, or to the complaint that you filed. And then I will just mention this: I don't know how often y'all deal with opposing parties who are incarcerated. I have a number of cases in which the opposing spouse is currently in jail. The time limits for filing responsive pleadings for people who are incarcerated is 60 days instead of 30 days. And also, I will mention that, if you don't do that often, I would advise you to go look at Rule 4 and specifically the provisions about how you serve someone who's incarcerated, because it's a little bit different than someone who's not. So there's some essential there's some essential information that needs to be included whenever you're filing a divorce complaint. So obviously the names of the parties, counties of residence for each individual, dates of marriage and separation. You got to include your grounds for divorce. If custody and is going to be an issue and there's children of the parties, their initials and dates of birth. I also like to specifically indicate whether, if we're dealing with when we're dealing with a divorce, is this a child that was born into the marriage, or is this a child that maybe was born prior to the marriage? And you're going to have some sort of a declaration in your decree indicating that the opposing party has been adjudicated as the legal parent. They're the legal father of that child. So that's kind of just something that I particularly like to do. And to be quite honest, it's almost as much of a reminder to myself as it is, information for the court that, hey, I need to bring, we need to either settle this between the parties, that we're not going to contest any paternity, or that I need to make sure that we bring this up at trial. Also, be sure to include a statement on, what your client's wanting in terms of custody and visitation. I try to, anytime that a lot of the cases that legal services filed may be uncontested because the other party fails to respond. So because of that, I try to include a lot of information in my divorce complaints. So whenever talking about the statement of custody and visitation, if my client is requesting something like supervised visits for the other party, I'll be sure to include a brief explanation of what the basis for that request is, simply so that if we have to go to court for an uncontested final divorce hearing, I can indicate to the judge that, hey, the other party was at least put on notice that this is what we were requesting and this is why. And so if they failed to respond, that's their problem. And it's not for lack of notice that they didn't know what we were asking for. And sometimes it works. I recently had a case in which that didn't work, and we're still required to try and get the other party to appear at a hearing, even though they had defaulted. Also, make sure that you're getting that verification signed and notarized by your client, by the plaintiff, if there's going to be children that are involved in that case. This is kind of, wrapping up the last couple of things to make sure you include requests for child and spousal support, requests that marital property and debts be divided. This is another area in which I try to be as specific as possible. So instead of just saying something like, plaintiff requests that the court, rule on marital property, or just some basic language that's real vague as to what you're talking about, I try to include property that I specifically already know about based on what my client has told me. Again, that's just, another thing, like I mentioned earlier, that if the case is going to be uncontested, I want to be able to tell the judge that, whenever I served the other party with this complaint, they were put on notice of all of these things being at issue in this case. And so, let's just go ahead and get a ruling on this. And they, the other party already knows about it. We're not keeping it secret or they leaving them in the dark about anything. Also make sure you include, something that's pretty basic, requesting the restoration of a maiden name for your client, requesting mutual restraining orders, temporary hearings, attorney's fees. All of this stuff is I'm sure, as y'all probably know in your own practice, that these last couple of issues on here are pretty standard across the board. So now we're going to kind of get into I'll say kind of the meat and potatoes of the issues that you need to address in a divorce case. So first of all, the residency requirement. There's a citation to the exact code provision where you can find the language for the residency requirement. So either plaintiff or defendant has to be a resident in Arkansas for at least 60 days prior to the date that the case is filed, that the actions commenced. And then they have to, either plaintiff or defendant, reside in Arkansas for 3 full months before the entry of the divorce. So essentially what that means is that you need 60 days prior to the filing, and you need at least 30 days after the case is filed before a decree can be entered. Residency means actual presence in the state. So these are the grounds for divorce that are listed in 912-301. Again, a citation to the exact code provision if you want to go and look at the exact language. So out of these 9 grounds for divorce, we primarily use number 5 and number 7, general indignities, and 18 months of continuous separation. However, you can also, it's also grounds for divorce if there's issues of impotency, conviction of a felony or other infamous crime, habitual drunkenness, cruel and barbarous treatment, adultery, 3 years commitment of a spouse to a mental institution, or failing to provide necessities of life. Like I said, we primarily use general indignities and 18 months of continuous separation, depending on the specific facts of the case. I actually haven't seen too many cases that are filed under grounds, under one of these other grounds, other than number 5 and number 7 on that list. So I'm going to talk specifically about general indignities, just because I think that that's probably the most common ground for divorce in cases that are filed. So the exact language is that that one spouse offers such indignities to the person of the other as shall render his or her condition intolerable, and that's found in 912-301 subsection B. So I included language from a couple of cases here on this slide and the next, kind of just to highlight what general indignities typically means. So the conduct that you're relying on to prove your grounds for divorce must be manifest settled hate, alienation, and estrangement, and consistently and systematically pursued with the purpose or effect of rendering one of that spouse's condition in the marriage intolerable. So general indignities, it has to be something that occurs over time and occurs repeatedly, as opposed to maybe just one instance of what the court in Walton v. Walton here described as manifest settled hate. So make sure that you're, when you're presenting evidence to prove your grounds for divorce, that it's something that has happened constantly and systematically over the course of the marriage, and those actions now render your client's condition in that marriage intolerable, so that they can no longer remain married to their spouse. This second citation here on the bottom of the slide just includes some language that courts have used to describe what could count as general indignities, or what kind of action or attitude falls under the label of general indignities. So that can be rudeness, unmerited reproach, contempt, studied neglect, intentional incivility, injury, abusive language, plain manifestation of settled hate, and then, like I mentioned before, alienation and estrangement. So it's a wide variety of actions that can constitute general indignities. Like Lynn and I had both mentioned, pretty much all of our domestic relations cases involve domestic violence, and so almost all of my divorce cases that I currently have or that I have had in the past, our grounds for divorce are going to be things like a pattern and a history of domestic violence, things like physical, verbal, and emotional abuse. And so those are, pretty specific to the types of clients and cases that we have. However, as you can see, from these two cases that are cited here, it doesn't just have to be physical violence or domestic violence in order to qualify as general indignities. The other thing I'll mention about general indignities is I guess kind of the level of proof that you need in order to meet your requirement of proving your grounds. So when the divorce is sharply contested, you only need slight evidence of corroboration of your grounds for divorce. So one of the requirements in order to get a divorce is that you have evidence of the grounds for divorce, and then you have corroboration of those grounds. A second person who can testify as to what the plaintiff is talking about in terms of their grounds for divorce. If the case is sharply contested, though, the corroboration doesn't have to be, you don't have to call a witness up there who's going to testify for 2 straight days about every bad thing they've ever seen the other party, do to your client. It just needs to be slight, the evidence just has to be slight. So, having them talk about 1 or 2 instances in which they may have seen, some physical violence, or, they've seen 1 instance of physical violence, but they've been present for numerous instances where there was verbal and emotional abuse. Those types of things in a sharply contested divorce case are probably going to be sufficient to corroborate your grounds for divorce. And then the second thing I'll mention on this same topic is that the combination of your client, the complaining spouse, and the witness that's there to corroborate, their testimony can't just be general and conclusory testimony that they're providing it as evidence to prove their grounds and corroborate the grounds. There needs to be specific, they need to talk about specific acts and language that show rudeness and contempt and the indignities that are complained of. So it's important that, what I try to do in my cases is get as specific of facts as I can in terms of when did, if you're alleging that, if, let's say that I'm representing a wife who wants to get a divorce and she's alleging that the husband has punched her in the past, I'll make sure that we try to include, when did that happen? What exactly happened? Who else was there when it happened? Those types of things to try and get, a lot of specificity as to what, specifically we're saying those general indignities are as our grounds for divorce. So like I mentioned earlier, 30 days have to have lapsed from the date that you file your complaint until the entry of that divorce decree. The cause of action has to occur within 5 years from the date of filing the complaint. So it's in essence kind of a 5-year statute of limitations. And then you have to corroborate grounds, residency, and separation. So you need someone else who's going to testify that your clients lived in Arkansas for more than 60 days prior to filing their complaint for divorce, that the plaintiff and defendant were separated on such and such date, and that they've remained separate since that date. And then also, like we just talked about in the last slide, to corroborate those grounds for divorce, and present testimony as to things that they've witnessed that would corroborate those grounds. So a big issue in a lot of divorce cases is going to revolve around custody of children. And I'm actually going to stop. Chrissy, are there any questions or anything before I kind of transition into this?
We don't have any questions just yet, but if you wouldn't mind let me doing a poll, that would be great.
Sure, absolutely.
Okay. So I'm going to launch another poll. This is really just to make sure we're keeping up with attendance and making sure people are present. We're just asking, when will you receive a CLE form? Because I get lots of emails about that, despite how many times I announce it. So make sure you're paying attention. Please answer the question. And I'll let Ryan go ahead because I don't need to launch the results of this. And you guys can, I'll try to move it out the way a little bit where you guys can continue answering.
Am I good to keep going?
Yes, yes,
okay.
sorry.
Okay. So one of the major, one major issue in a lot of divorce cases is going to revolve around custody of children. It's important, kind of the first thing that you need to look at, even in the initial stages before you file your complaint, is whether the court you're filing in is going to have custody or is going to have jurisdiction over the children that are at issue in your case. So before a court in Arkansas has the authority to decide custody and visitation of a minor child, they have to have jurisdiction over that specific child or those children if there's more than one. That jurisdiction is covered under the UCCJEA Uniform Child Custody Jurisdiction and Enforcement Act. The statute for that can be found at 9-19-101. So where it starts, it's fairly straightforward in terms of the things that I guess are going to be the most prevalent in cases. Now there's, you may have a specific, complex issue where you need to go and look at the specific language of the statute, but the basic workings of it are fairly straightforward. Essentially, the UCCJEA requires Arkansas to be considered the home state of children for an Arkansas court to have jurisdiction over them to decide things like custody and visitation. So generally, in order to establish Arkansas as a child's home state, children will have to live here for at least 6 months prior to the date that divorce lawsuit is filed. If the child's younger than 6 months old, they would have had to have lived here from the time they were born until present whenever the case is being filed. Once an Arkansas court asserts jurisdiction and rules on custody and visitation, then Arkansas will have continuing jurisdiction over those children Until the parties and those children then move from Arkansas to another state, and that becomes the children's home state after they've been there for 6 months. So essentially, Arkansas has jurisdiction for an initial custody determination only if they're the home state of that child, meaning that the child's been here for 6 months or more prior to the date that the complaint is filed, or Arkansas was the home state within the last 6 months, and the child, let's say the child's now gone from Arkansas in a different state, but one parent still lives here, and then this new state that the child is living in has not asserted jurisdiction over that child. So those are kind of the two basic ways that Arkansas has jurisdiction to rule on issues of custody involving children. So I wanted to touch on joint custody just because I mentioned there's been a change in the law with this most recent legislative session. So there's been a trend throughout courts in recent years for courts to award joint custody of children to their parents. The old, I'll say old law, but what the law still, this provision is still in place, but it's been added on to. So previously, an award of joint custody was favored in Arkansas. With the passing of Act 604, there's now a rebuttable presumption in original custody determinations of either divorce or paternity. There's a rebuttable presumption that joint custody is in the best interest of the child or children. In order to rebut that presumption, the court has to find by clear and convincing evidence that joint custody is not in the best interest of the child or children. The Act 604 has added a rebuttable presumption into these issues of joint custody, and it's also raised the burden of proof from preponderance of the evidence to clear and convincing in order to rebut that presumption. The other thing that Act 604 has done is it's put, I guess, a more firm requirement that if a judge is going to stray away from an award of joint custody, that there needs to be specific language in terms of findings as to why joint custody is not being awarded. And then they're also, whenever you're dealing with implementing parenting time for non-custodial parent visitation awards, the judge has to include in the order very specific instructions as to frequency, timing, duration, and condition of that visitation. So, I think in terms of Act 604, I don't think, putting in there that the non-custodial parent gets reasonable visitation is going to suffice anymore. I think that the legislature is looking for more specific details in terms of what, when exactly is this non-custodial parent going to have visitation with the child? How often is it going to be supervised or unsupervised? What are the conditions going to be on that visiting time? Instead of, just a kind of a vague blanket statement as to when that parent's going to see the children.
We have a question in the chat if you'd like to take it.
Sure.
Okay. If parents in uncontested divorce agree to other than joint custody, is that enough, or will they have to convince the judge?
That is enough. So I skipped over. I would encourage people to go and read Act 604 for the exact language of it, but that, agreement of the parties is specifically one of the things that's listed, that the presumption for joint custody can be rebutted, like I mentioned the first time, if there's clear and convincing evidence that it's not in the best interest of the children. And then the next point down from that is if the parties have reached an agreement on all issues related to custody of the child. So if it's uncontested and the parties agree, one parent has sole custody, the other parent has, reasonable visitation at, on these dates at this time, then that should be sufficient. Are there any other questions before I keep going?
Not at this time.
Okay. So joint custody, even with this new Act 604, joint custody still isn't mandatory. There's still discretion left to the judge to hear evidence on those best interest factors and to make a ruling on what's in the best interest of the child. And if the judge determines based on the evidence presented that best interest is not in does not indicate that joint custody is a viable outcome for this child, then the judge doesn't have to award joint custody. So joint custody typically means that there's roughly a 50-50 split in parenting time, or as close to 50-50 as you can possibly get. Now, as I'm sure anyone who handles domestic relations cases, and specifically cases involving custody, probably knows, once a child reaches school age, it's pretty difficult to have truly 50% of the time with one parent, 50% of the time with the other. So like it says here, it's rough. It's generally, when you're talking about true joint custody, it's as close as you can reasonably get to a 50-50 split. However, it can be divided other ways, where it's not as close as you can get to a 50-50 split, but still be joint custody. Joint custody is also going to require parents to cooperate and co-parent on issues that would typically fall under legal custody, like where the child's going to go to school, religious upbringing, medical care if the child needs it, those types of decisions. And to kind of go back to Act 604 again, there's also provisions in here. This is why I would encourage everyone to go and look at the specific language. There's also some additions in here in terms of the judges trying to implement solutions in cases where joint custody may be an option, but let's say the parents can't stop fighting long enough for it to be viable. There's language in here that now encourages judges to try and implement a solution to the communication problem between the parents to try and make joint custody viable, to try and solve those issues. If that's the only barrier to a joint custody award, is the parents' inability to communicate with one another. So like I said, I would encourage everyone to go and read that and kind of see specifically what those additions to joint custody and co-parenting provisions and things of that like are. So when determining custody of a child, the court's primary and sole consideration is going to be best interest. What's the best interest of this child? And what custody arrangement can the court order that's going to be in that child's best interest? So there's a bunch of factors that can be considered in determining what's in the best interest of the child, including specifically psychological relationships between the parents and the child, need for stability and continuity in the child's relationship with parents and siblings, past conduct of the parents toward the child, and the reasonable preference of the child. That last one is going to be dependent on, obviously dependent on the age of the child. The child has to be of sufficient age in which to, be a competent witness to testify as to their presence before the court's going to take their reasonable preference into consideration. And also the court's going to take into account, the child's age and experience in life and those types of factors, that are typically dealt with when talking about a child testifying, in order to kind of, weigh what the child's saying versus, how impactful it should be in the court's determination of best interest to award custody. So best interest is defined very, very broadly. Essentially, it means that the court's going to look at every aspect of both parents' lives to decide how we can, what arrangement can be ordered by the court that is going to get, is going to be best for this child or children that are being dealt with in this case. Just to give an idea of kind of the broad range of things the court's going to look at: caregiving responsibilities of children, employment, church attendance, how long you've lived at a specific address, sexual relationships, whether you are co-parenting, or not co-parenting, whether you're cohabitating with another adult to whom you're not married or who's not a member of your family. Your friends and associates, if there's history or evidence of present alcohol or drug abuse, mental and physical health, criminal record. Like I said, it's, the judge is going to go into all aspects of life for both parents to try and make this best interest consideration, or this best interest analysis. And I think Lynn may have mentioned this earlier, but there is a presumption that if a parent has been involved in perpetrating a pattern of domestic violence towards the other parent, that the abuser in that situation should not receive custody of the child, or should not be awarded custody of the child. That's a presumption that can be rebutted, with sufficient evidence. But I think it's helpful in terms of, specifically for cases that we deal with, and that, if there's a, if we have an accompanying order of protection case in which we're also representing the same client from the divorce case, I think it's a good argument to be made to the court in the divorce case dealing with custody that, hey, if there's a final OP that's entered, there's this OP was entered based on a pattern of domestic violence, and there's a rebuttable presumption that this abuser should not be awarded custody of the child. Now, I think Lynn mentioned that she has dealt with a case in the past in which that didn't fly, and the judge, still awarded joint custody in the divorce case. But I think it's at least a strong argument to make in trying to get your client the best possible custody outcome, or the custody outcome that they are looking for. So generally, when there's a non-custodial parent, if you're not awarded joint custody and there's a non-custodial parent, they'll get visitation with the children. There's no standard visitation that's statewide. They're typically, from what I've seen, published by judicial circuits as to what, judges in that circuit, if they all agree, what their standard visitation schedule is going to be, or a judge's own specific standard visitation schedule. Usually the standard visitation schedule is going to be some amalgamation of, visitation with the non-custodial parent every other weekend, and then one night or evening during the week, as well as, summer breaks and alternating holidays. So it may be, one circuit's standard visitation schedule could be Friday afternoon to Sunday afternoon, and then another would be, Friday afternoon to Monday morning school drop off. So there's slight differences, but they all kind of amount to this, about the same amount of time, and kind of the same schedule. Trial courts can grant supervised visits if the court finds that that's in the children's best interest. Usually those are only awarded whenever there's proof that the non-custodial parent's been abusive or neglected the child or children, or if there's proof of a drug addiction. Obviously, when I say abused or neglected, that can include physical, evidence of physical abuse. If there's, hopefully y'all don't have to deal with cases like this, but evidence of sexual abuse of the children by the non-custodial parent would also, at the very, very, very least, hopefully you could convince the judge to award supervised visits. But, I think probably more, a loftier goal should be to try to get no visitation in cases where that's there's allegations of sexual abuse. And then, like that last point and kind of what I just touched on, if the abuse is severe enough, then the judge can award no visitation. Typically, I think no visitation is probably the language in the order would include, I guess, kind of leave the door cracked open for the non-custodial parent to say something along the lines of that they're awarded no visitation unless they petition the court at a later date, where then the events or the facts that led to the award of no visitation are going to be revisited by that court to determine whether or not the non-custodial parent now should get some sort of visitation rights. Non-custodial parents are required to pay support. That's all determined by admin order number 10. I'm not going to go into the specifics of admin order 10. It's pretty, it can get pretty complicated based on what the income levels are and different financial factors of the, specific parties to a case. I will say, prior to trial, each party, needs to exchange affidavits of financial means that set out income, living expenses, and then those are going to be used to calculate a child support request. I believe per the language of admin order 10, you're not supposed to file the affidavit of financial means, just supposed to file the child support worksheet. The court can deviate from your request, from the presumptive amount on the child support worksheet. Typically, the judge is going to have to state specifically why the deviation, why they're ordering that deviation, and can't just say, I'm going to award this instead, and that's it. Child support automatically terminates when the child turns 18 or graduates from high school, whichever is later. And child support can continue past the 18th birthday in cases when the child is disabled. Also, if you're dealing in cases where there is an arrearage of child support, that can continue. Payment on the arrears can continue after the child turns 18 as well. Spousal support or alimony, typically awarded to rectify an economic imbalance in earning power and standard of living between divorced parties. There's kind of two primary factors that the court's going to look at. It's going to be the needs of the spouse requesting alimony and the ability of the other spouse to pay. And awards of alimony are within the discretion of the trial court. So they're not going to be reversed unless there's an abuse of discretion, which is pretty difficult to do. So they're typically not going to be reversed. And Arkansas does allow for temporary alimony to either spouse during the pendency of a divorce action. And alimony can be awarded on numerous different bases: permanently rehabilitative or as reimbursement. And it typically terminates when the party who's receiving those alimony payments remarries, starts cohabitating with someone who they have an intimate relationship with, or have a child with someone after they get divorced. And it can be terminated if there's a change in economic condition of either party or upon the death of either party. And it can be modified, when the economic condition of either party changes.
Hey, Riley, we had a question. I think it was
Sure.
maybe a slide back. In uncontested divorce, how hard is it to waive child support if both parents agree? Is it allowed?
I think it depends on a couple of things. So if there's an award of joint custody in uncontested divorce, I think typically if it's true joint custody where there's this close to a 50-50 split, I think it's not too difficult to get the court to order no child support. If that's not the case, if one parent is the primary physical custodian of the child and has the child a majority of the time, I can't remember off the top of my head, but I believe that there is some case law that says that and Lynn, hopefully you can jump in if you're still at your computer. I believe there's some case law that says that the support obligation is owed to the child, not the other parent. And so I don't think that parents can agree to waive that obligation on behalf of their children.
I mean, I think you have to know your judge. Since the new guidelines went into effect, a little over a year ago, I've had it all over the board. I've had joint custody by agreement of the parties where the judge still made us do a divorce worksheet. I mean, a child support worksheet. I've had judges impute SSI benefits. received by the custodial parent or the child as income to the parent, which I think is absolutely prohibited by the new guidelines. But it also uses those words, judge's discretion, which is really hard to get around. I think in the case of SSI, we're going to have to appeal that. And then I have had judges, I guess I shouldn't name names, but I've had judges who, if you make an agreement, they're going to sign off on it. And I would say that's the majority of the judges. I think talk to your colleagues about what particular judges do, but judges really like agreements and they almost always sign off on them. That's my 2 cents worth.
Yeah, and I think it's definitely, I think it matters how the case is uncontested, if that makes sense. So if the parties are in agreement on everything, and so it's uncontested on that basis, like Lynn said, I think judges will like an agreement and will sign off on it. If it's uncontested because the other party failed to file a response and are in default, then I think that that's kind of a different circumstance than if there's an agreement on everything, and the judge may, impute income or whatever it is that they feel that they need to do in terms of child support.
And then we also had a question about difficulties in calculating the new child support worksheet. It's not as easy as before. But on that Administrative Office of the Court's website, there is a a calculator on there. And lots of judges, you can see them doing that at the bench when you're trying a case. So I would just, recommend that you take a look. That might help a little bit.
Yeah, and I don't know that we're necessarily in the best position most of our calculations for child support are very easy because our clients are low income and don't have a lot of money, and their spouse is kind of in the same boat a majority of the time. So, we're not really going to be dealing with, in our cases, some of those exceptions and things that reduce, income that can go towards determining the child support amount. So our cases, I think, are probably a little bit easier maybe than someone else who has a private divorce practice. Okay, are there any other questions on custody, support, alimony, anything I just went over?
We don't have anything in the chat for Q&A at this point.
Okay. Oh. All right, so we've kind of covered custody, child support, alimony. We're going to kind of move into division of property at this point. This can be another big area of a divorce case, depending on how much property and how much marital debt the parties may have. So kind of as a general rule, any property the parties acquire during marriage is typically going to be considered marital property and subject to division in to an equitable division in the divorce. The property division statute specifically states that the court has to attempt to equitably divide marital property. So usually a lot of times that comes out to, splitting things 50-50. However, there are, specific statutory factors that are listed. If you go and look at the statute that will tell you there are certain things evidence that you can present to the court to show that, a 50-50 split would not actually be equitable, and we need to divide property in some other way. Exceptions to that general rule that I stated are going to be things that are gifted or inherited by either spouse. Those are not, that type of property will not be considered marital property. Property that's owned by either party prior to the marriage is typically going to be classified as separate property and not subject to a division. However, I would kind of state as a warning, separate property, gifts, inheritances, things owned prior to the marriage, those can all be converted into marital property. I think one, kind of simple example of how that can happen, at least that I've seen so far, is that if, one spouse owns a home that let's say they purchased it prior to the marriage, so it's pretty clearly non-marital property. Well, if, after they get married, if the spouses, use income that they earn while they're married, or get, take out a home equity line or something like that and make substantial improvements to the home, then the court can award, can say that any increase in value to the home due to those improvements that were made with marital property is now considered marital property. So a portion of that home that was, 100% separate property can now be considered marital property subject to division. So, the status of property can change depending on what the parties do with it. Any real property that's owned jointly by the parties during marriage is automatically, by operation of law, going to become property held as tenants in common whenever a divorce decree is entered. And then, like I said, a lot of property division typically comes out to a 50-50 split. You can't cut a house in half and give half of it to one person and half of it to the other. So, if the parties can't agree on what's going to happen with things like a home that are purchased during the marriage, the judge could order that property be sold either at a public or private sale. And then the money that is made, after you satisfy mortgages and liens and costs of sale and things like that, anything left over to be, can then be divided between the parties. Like I mentioned before, property is usually divided equally, but the judge has discretion when dividing property, and can even divide separate property when it's going to be equitable to do so. When you're dealing with things like 401ks and retirement accounts, IRAs, you're going to need a separate order called a qualified domestic relations order that you'll need to have that signed by the judge, and then submit that to whatever company or whoever the plan administrator is of that retirement account. So when you're dealing with things like retirements and 401ks, there's kind of an extra step that has to be done in order to make sure that you get those benefits paid out to your client if they're awarded some of them as part of a property division. So like I said, it's the quadros or the qualified domestic relation orders are required for retirement plans that fall under ERISA, which is a federal statute. And essentially what the quadro does is it tells the plan administrator how the retirement account that they're managing is going to be divided based on the divorce and what, whether or not there needs to be, a monthly disbursement of the retirement plan needs to be, sent to another person instead of, just the person who owns the plan, or if there's some sort of a lump sum payment, or, whatever the terms of the property division for that account are, the quadro kind of spells it out for the plan administrator. So the, whoever holds that retirement account knows what's going on, knows who needs to receive money, and has, a document that's a judicial order that tells them, this is what you need to do. In order for retirement accounts to be eligible for division as marital property, they have to be vested. The vesting, when a retirement account vests, is going to be determined by the party's employer or the plan administrator. And if you don't know what the plan vesting means, it simply means that, I guess to give a simple example, if you were hired by a company and they contribute, let's say they match whatever you contribute to your 401k, they can tell you as part of those conditions of hiring that maybe, you can't, if you leave before 7 years, then the portion of your plan that we contributed, you're not going to be able to take with you. So once you reach the 7 years, then your plan is vested, and all of the money that's in it is now under your control, and there's no, strings attached to it by your employer. It's considered vested if it can't be diminished by the employer, meaning they can't remove any money from it that they may have contributed, and it's not dependent on continued employment. I think I've already mentioned, divorcing spouse usually entitled to half of the benefits that are accrued during the marriage. Division of military retirement pay is pretty specific, and it's covered by an entirely different federal law, Uniform Services Former Spouses Protection Act. Similar to other retirement accounts, it has to be vested before it's considered marital property and subject to division. And typically a service member has to serve at least 20 years before their pay is considered vested. For the federal statute that was referenced here on the former slide, the Uniform Services Former Spouses Protection Act, what that does is it authorizes the federal agency that administers and sends checks out to retired military personnel. It authorizes them to send a check directly to this former spouse as part of the property division, instead of the money going to whoever the retired military person is, and then they have to maybe divide that money and then send something to their divorcing spouse. This authorizes direct payment to that divorcing spouse. So in order to qualify for that, the former spouse has to have been married to the member for a period of 10 years or more, during which that their husband or wife was a member of a military branch and performed at least 10 years of service creditable towards their retirement eligibility. The 10-10-10 is what that rule that I just talked about is called. That doesn't apply to a court's authority to divide retired pay, only the ability of the former spouse to enforce the award for direct payments from Defense Finance Accounting Services, which is the federal agency that authorizes payment of retirement benefits. You have to have something similar to a quadro whenever you're dividing these military retirement benefits, but it's specific to military retirement plans. Debts incurred by either party individually or jointly during the marriage, usually going to be considered marital debt and usually divided between the parties 50-50. There is no requirement in the language of the statute that deals with marital debt that requires that marital debt be divided equally between the parties. It's the only considerations are going to be each party's ability to pay the debt, and what happened with dividing all of the other property that was part of the, that were marital assets that have previously been divided. Debts incurred prior to marriage typically aren't going to be considered marital debts, typically going to be the sole responsibility of whoever incurred that debt. As with division of property, judges are going to have discretion when deciding division of debts, and can order that they be divided unequally if doing so is going to end up being the fairest way for those debts to be divided. Regardless of how the court divides debts between the parties, the party's still going to be liable to a creditor for any debt listed in his or her name. So typically you're going to have to include some clause indemnifying a party if they're no longer responsible for payment of a marital debt. The person responsible is going to have to indemnify them for any cause of action that results as a result of their non-payment on that debt. No jury trials and divorces. You can do temporary hearings on custody, visitation, support, alimony, use of marital home, division of property. Usually those temporary hearings are going to be pretty shortly after the defendant files an answer. As I'm sure everyone knows, the time frame for a divorce, or the time limit for a divorce hearing can be, as many as a couple of days or as short as 15 minutes, depending on, what your needs are in the specific case. I think we're getting pretty close on our time, so I'm not going to go through all of this specifically, but the Service Member Civil Relief Act, if you're dealing with a case that involves an active duty military member, you're going to need to be sure to be aware of what this federal law does. Essentially, it allows someone who's on active duty in the military to apply for and receive a stay of a civil proceeding in state court. so that they can make arrangements so that they can appear and defend themselves against any lawsuit that's been filed. There's specific things that the service member has to do in order to get that stay. The stay is usually, I think the minimum amount of time for the stay is typically 90 days, but can be more. And the active duty service member can apply, if they apply for a stay and are granted, say for 90 days, after that 90 days is up, they can apply for another stay as long as they show, that they're still on active duty, that their military service hinders their ability to be involved in the case, and they have, good grounds that a judge is going to agree with. So like I said, if you're dealing with an active duty military member in a divorce case, just be aware of this, the Service Members Civil Relief Act. Let's see, there's a couple of, I think probably the biggest post-decree issue to be aware of is going to be, changes in custody. And that's going to be, you're going to have to look for this, kind of the standard thing. Is there a material change in circumstances? And if there is, what's now in the best interest of the children in terms of a custody arrangement? Any sort of leaving the state is going to be governed by Hollingsworth, which is, if you're dealing with a case that involves a custodial parent leaving the state, I would advise you to go look up Hollingsworth. That it sets out some factors that relate around there being a rebuttable presumption that a custodial parent is allowed to leave the state with the children. And then the non-custodial parent essentially has to present evidence as to why they shouldn't be allowed. And there's a couple of factors enumerated in that case that are going to be helpful if you're dealing with that type of issue. And then I think that's all we have time for.
Okay, do we have any more questions before we wrap up today? I'll give you a few minutes to put them in the chat. I'm going to go ahead and launch another poll just, just in case someone missed one and they're worried about getting credit. We'll go ahead and launch that. But thanks you guys so much for being here. We really appreciate you, Lynn and Riley. That was very, very informative. And like I said, that was a lot of information. So if you need to review it again, we will post this on our YouTube page, and the slides are available. If you didn't get them by email, just shoot me an email and we'll figure out how to get them to you, because they were, for some reason, the file was just really large. We do have one more question that came in. You addressed moving out of state. What about moving in state, but out of school district?
Oh, it's really going to depend, I guess, on the specific language of the decree or custody order and kind of what the custody arrangement is.
I was going to say, yes, I agree. If it's any kind of joint custody, then most of the time, and I would urge you to put this in your decrees, is that if it's joint custody, somebody needs to have the final say. And so you would go to that. But if it's strictly 50-50, I think the judge is going to look at the best interest of the child. For a little kid, maybe it doesn't matter so much if you change elementary schools. But if you're in like Pulaski County with magnet schools and all those kinds of things, I think it'll be best interest of the child. Don't you, Riley?
Yeah, I agree. And to kind of build off of what you said, Lynn, I think if you have a situation, let's say, where it's, joint legal custody with a primary physical custodian, so, 50-50 on making the decisions in terms of education, healthcare, things like that, but one parent has the child a majority of the time. I think typically what happens is that you're supposed to try to come to an agreement on a decision like moving schools, but if you can't, then whoever the primary physical custodian is typically has the last say. And then obviously if you have sole custody, I think it's up to the parent who has, the custodial parent. But yeah, if it's true joint custody with 50-50 parenting time, it's probably going to have to be, if you can't agree on it and have to go to the judge, it's probably going to be based on best interest.
Okay, and then really quickly about depositions. So divorce by deposition is basically by affidavit. So in other words, the testimony of the party and the witness is put in an affidavit, signed and notarized, filed, and along with a proposed order. Not all courts do it. I would recommend a call to the trial court assistant to find out if that judge does it. For example, Judge Reeve only does it if the parties have been separated for 18 months. Judge Parker won't do it at all. Judge Weaver won't do it at all. That's Faulkner and Lonoke counties. So rule of thumb, call the TCA and find out what the judge wants you to do.
But I think other than Reeve and Pulaski County, at least, I think all of the new judges will do it. And I think I think it's Reeve and then the Johnsons and Tucker, who I think are handling domestic relations cases in Pulaski, and they will all do depositions.
Okay, well, it looks like that's it, and we're at our time. And again, thank you two very much for being here. It was a very informative presentation, and your emails are in the chat if anyone has any follow-up questions or needs to reach out for guidance. And I guess we will see everybody next time, except for Lynn. We're going to miss you, Lynn.